All right. All persons having business before the honorable judges now presiding of the District of Columbia Court of Appeals. Draw near and give your attention. God is the United States and the honorable court. The honorable court now in session. Please be seated and come to order.
Good morning, everybody, and welcome to the District of Columbia Court of Appeals. It's nice to see everyone this morning. This morning, we have 3 cases on the regular calendar. The first one is number 22-CO555 Jesse Redmond Jr. versus United States.
Thank you. Good morning, Honors. If it please the court, my name is David Ryder and I represent Jesse Redmond, who requests that this court reverses conviction because when the government submits false evidence and knew it was false or should have known it was false at the time of submission, and that evidence dealt with identity, that NAPIU violation is material and that error is not harmless. And if the court would allow me just about 2 minutes, and we'll inform the court that we believe this is an issue that is one of first impression before this court. As this court is well aware, the United States in its briefs and motions to this court have admitted that the hair and fiber testimony submitted in Mr. Redmond's trial was false, or they should have known it was false. It is Mr. Redmond's position that that NAPIU violation is material and it was not harmless. Now, as this court well knows, expert witnesses are not normal witnesses. Normal witnesses do not come to court and back up their testimony with a litany of degrees, certificates, and training. And in this case, this specific expert witness was called for one thing: to prove Mr. Redmond's guilt. Now, the United States tries to play down the importance and materiality of the expert. They said the expert had just about 1 year at the FBI and most of it in training. The United States also admits in its brief that the expert had no advanced degrees and was noticeably green.
Mr. Ryder, I'm
Yes.
sorry, I know you want to jump into the transcript and the testimony and all of that, but there seems to be a lot of ink devoted to a threshold question of what the standard is, the standard of materiality, the standard of harmlessness. Can you, the government is arguing that Brecht applies. This is sort of a confusing thing because we're talking about which party has the burden and by what standard do they have to show this? Why isn't the government correct that Brecht and the sort of actual prejudice standard would apply to a NAPU claim that is raised in essentially what is habeas in DC?
Certainly, Your Honor. Well, certainly the United States bases that Brecht approach, in other words, showing a material and substantial injurious effect on the verdict. It is Mr. Redmond's belief that that is not the appropriate standard. The United States cited United States versus Smith, that's that Fourth Circuit federal case, as support. And they cite Brecht, and Brecht's standard or reasoning for that type of review was based on 3 pillars: the very nature of collateral review, society's interest in the finality of verdicts, and finally, issues of state and federal comity and to protect against abuses of habeas writ. None of those reasons apply when the United States has submitted false evidence. One, false evidence submitted at trial that is unbeknownst to the defendant at the time of trial really doesn't fall squarely into a true secondary habeas review. And second, society has absolutely no interest at all in basing criminal verdicts in whole or in part on false evidence.
Well, what about, why would perjured testimony, for example, face a lower bar than suppression, suppression, Fourth Amendment violations that we know are subject to Brecht review in habeas.
Certainly, Your Honor. Well, there's no question that the United States has cited, I believe, the 4th, 6th, 8th, and 11th circuits that go along that line of reasoning, but not all federal courts do. The reason is that when the United States or prosecutor submits false evidence, it is a direct violation of 14th Amendment due process rights, and that is extremely prejudicial.
And
And
are you adopting the argument of basically the Third Circuit and the Ninth Circuit? Do you see them as consistent, and is that your argument?
Yes, I do. And also, what's really important for this court to notice is that in those federal courts that are using the Brecht standard, when they had that sort of perjured testimony, that was Clay and Treppel. There's significantly different facts. One, in Clay, the government had 40 witnesses. In Treppel, that federal case, there was 70 witnesses, and the actual science of the expert testimony was not in question. In Mr. Redmond's case, there is just one witness, and the science that the government used in its direct evidence and vouched in its closing statements is just not true. This is not the evidence here. I know the United States respectively tries to say, well, it only provided marginal corroboration. That's not the case. This hair and fiber testimony wasn't alleged to have been located in the complainant's hallway of their apartment. It wasn't alleged to have been located in the kitchen of the complainant. It was alleged through this witness, which we know it's not true, that hair and fiber evidence was found in the bedsheet of the complainant. And that is material evidence that was not true. That's what makes this case different, and why really this court should decide according to the Fourth Circuit, and I believe that case is Haskell versus Green. Because again, when the government submits false evidence, that is a direct due process violation. And as Haskell cites, if it's material under NAPIU already, it's definitely likely, more than likely, that it affected the jury's verdict. And that's what makes these cases different than what the United States cited for the analysis of the Brecht
Right,
standard.
but the government says, when you look at all the actual testimony that came in this case, this isn't one of those cases where the false testimony made any difference, because you've got, there may be a challenge to identification, but it is a complainant who has known the defendant for decades. And there's evidence, that pretty reliable evidence. In fact, I believe even from the mouth of the defendant, that he was at the scene of the offense. So, there is all of this evidence in this case. Why doesn't that, overcome the effect of the hair testimony?
Certainly, Your Honor, for these reasons specifically. One is, this court knows in a prior decision with Mr. Redmond in this court, which the defense challenged the reliability of the identification that went on in court. It is true that the complainant knew Mr. Redmond 29 to 30 years, but this court needs to re-examine that identification for these reasons. One, the complainant did not identify Mr. Redmond until 24 hours after this event. Second, again, there is really one fact-based eyewitness. It was the complainant. And when the complainant came to court, she did not identify Mr. Redmond, not once, not twice, but on a third time gave a quasi-identification of Mr. Redmond while the courtroom clerk and U.S. Marshal was standing next to him. We think the court should have serious concerns. Now, is it reasonable that a jury would witness that and then look at that expert witness who the government testified and presented as gospel when it in fact was apocrypha, to say, oh, we have hair and fiber testimony and it's consistent with Mr. Redmond. We know that's not true. That's why it's material.
What was the defense theory?
Well, the defense theory was arguing again in the appeal that identification was unreliable and that the complainant wasn't telling the truth. Again, there is.
Did the defense take a position on whether a sexual assault occurred or not? Like they were just saying running a kind of reasonable doubt offense.
I think it was the reasonable doubt effect. But for this court to decide, because it is a principle that will be applied to other cases in these type of circumstances, when the government submits false evidence.
I want to be sure that I understand what you mean, Mr. Ryder, because you've repeatedly referred to false evidence. I think we're all on the same page with respect to understanding that this hair testimony, hair and fiber testimony, in this case and many others has been discredited. It's not scientific, et cetera, et cetera. But I'm wondering if there's a distinction between false evidence and unreliable evidence, and you have repeatedly used the word false. So I just want to be sure that I understand what you mean. And you gave us an example. You said this wasn't evidence that was found in the hallway or in the kitchen, but it was supposedly found in the bedroom, and that's just false. Is that what you meant to say?
Oh.
And let me acknowledge, I haven't read all the transcripts, so I'm not sure. But where we are right now, is there agreement that the testimony that hair was found on the bed sheets is false, or is it just that? And I don't mean to minimize this when I say just that, but is it just that the expert should not have been permitted to say as forcefully as she did, if it was forceful, that the hair was consistent with the defendant's hair? Just what is it that you mean by false?
So,
do you mean unreliable, or do you just mean untrue?
Untrue, yes.
In what way was it untrue?
The hair was found, but the science, and when this expert got on and swore under oath that hair was consistent with Mr. Redmond, that's not true, because that science can't prove it. I think if the court looks at Haskell versus Green, that was that Third Circuit case, a lie's a lie. Whether it goes to the credibility of the science or the person.
Well, I guess that's what I'm having trouble with, because we know, and this is not part of the trial transcript, that we know that subsequent to trial, there was the mitochondrial DNA analysis, and that seems to show consistency at the very least between the hair found on the bed sheets and your client. So is it really correct to say that the testimony was untrue? It was not based in science, we can say that. It was unreliable, we can say that. But false, can we really say that? I'm not sure it makes a difference, but I was just struck by your repeated use of that word and wondering whether it makes a difference to our analysis. Because you might think to yourself, surely it's such an egregious thing if the government were to present a witness that it knew was lying. You know, the witness says, I saw him there, and the witness was 1,000 miles away and couldn't possibly have. To knowingly present that testimony is about as egregious as one can imagine. This doesn't quite seem to be that, even acknowledging all of the problems with hair analysis, and I think we do all acknowledge it, so.
Well, actually, some of the cases, the phrase that is used, perjured testimony. I don't think it makes a difference, because when you raise your hand under oath and say you are an expert for the reliability and testify as to the reliability of that evidence, and you say something that in fact has no scientific proof, you're not telling the truth.
Well, that's a good point, which causes me to ask you, what of the government's argument that this expert acknowledged that there was no scientific proof of certain aspects of her testimony? And again, I apologize, I haven't read her testimony, so I can't describe it precisely. But according to the briefs, she acknowledged that she couldn't say with certainty, or there was no empirical evidence for those sorts of disclaimers she apparently made. What do you say to that?
Well, Your Honor, I would say this. The actual testimony of this witness was the hair is consistent with Mr. Redmond. And under this fact pattern, could the jury conceivably take that testimony and say, you know what? I had doubts about this witness when they were the complainant, when they were testifying, but you know what? This witness, who's an expert, who testified they had all these degrees, again, expert witnesses are not normal witnesses. They're called specifically to bolster the case. And the United States called this witness in its case in chief specifically to call his guilt, to prove his guilt. I think the government, in whatever explanation they can say to play it down, if that were the case, why did they call this witness to court? They called this witness to court specifically to prove his guilt. And I see my time is up, but I will say one thing. The United States did say in its brief, well, the testimony was only about 9 pages. I leave the court with this. If one witness stands up at trial and all they do is stand up and point to the defendant and say, that's the man, and that's all, that's just as powerful. That 1 minute is just as powerful as it would be 1 page of testimony, 10 pages of testimony, or an hour on the stand. That's why this was significant, and that's why this was error, and the case should be reversed.
Let me just ask you one question, and you addressed this some in your brief, but if there's any points you'd like to highlight on this, where did the impeachment of that witness fail?
Well, that's a good question, Your Honor. How can you impeach something when you don't know that testimony is not true? You're in a tremendous disadvantage. If for some reason the defense knew absolutely and could categorically prove that hair and fiber, how many convictions have we had on that tool mark, later discredited by this court? I cannot think of any more disadvantageous position without knowing that that science is discredited. And in this case, a very powerful piece of evidence. That's why this is different, Your Honor. If the court has no more questions, I will reserve the rest of my time for rebuttal. Thank you.
You're out of time, but we will definitely give you a few minutes for rebuttal.
May it please the court, Mark Lavelle of the United States. Mr. Ryder said something interesting. He said, if the expert had pointed her finger at Redmond and said, this is the guy, I can identify him, that would be more damaging than 100 pages of testimony, or whatever it was. And if that's what Karen Lanning had testified to, unimpeached, I would take my hat and I would go home. Because that case would be Jones. That's what happened in the Jones case, in which an experienced FBI hair expert came in and in this court's words, positively identified the defendant to a high degree of certainty based on hair analysis and microscopic hair testimony. And we know now microscopic hair testimony can't do that. Arguably, we knew at the time that microscopic hair testimony is not a positive means of personal identification. It's not like fingerprints. It's not like DNA. But it is also, and I think this is the nuance, I think Judge Thompson, your questions were getting directly at this. It's not fair to say, and it is not accurate to say, that it is junk science, that it has no use. There is a limit, and respectfully, Karen Lanning, to the extent that she crossed that limit, she didn't cross it by much, not like the examiners in Jones and Nelson. And she was rigorously impeached, and the trial court found that she was rigorously impeached, and the weight of her testimony was significantly undermined. And respectfully,
think that
Mr. Ryder has.
Oh, I'll let you finish that.
Sure, Mr.
sentence.
Ryder has not satisfactorily answered the court's question about why did that impeachment did not have the desired effect, because what he's saying is Karen Lanning's testimony pointed the finger directly at Redmond and said, I can positively ID him. But on cross-examination, she admitted, I can't do that because hairs can look the same.
Right, but do you think that you can draw from her testimony properly? I'm trying to get at what you mean when you say to Judge Thompson that it's not completely bad evidence or something. Can you draw from her testimony that Mr. Redmond's hair was in the bedroom?
To the extent you could, that inference was completely undermined, devastated by the impeachment. And here's what I mean by that. And let me also address in addressing that question, what the science can do and can't do. The science of hair, the science of hair examination, you can include and you can exclude. In other words, an examiner can look at two different strands of hair and say, based on my examination of the macroscopic and microscopic characteristics of these two hair strands, in my expert opinion, these did not come from the same person because they don't share the characteristics. They can also look and say, because these two hairs share the same characteristics, the known sample is included among the potential contributors to that hair.
Is that the same thing as being consistent or it's different?
They used to testify and say consistent. They don't do that anymore because arguably consistent could, it's stronger phrasing and you could draw the sort of inference that maybe that Mr. Ryder is suggesting that you draw. So what you can do is you can say, I'm including, but I can't tell you how likely, what the odds are against, what the odds of this person actually giving that hair. It's you can rule somebody out, you can rule somebody in. And to the extent that Lanning's testimony that the hair was consistent with Redmond's hair, went beyond the limits of the science. As the trial court found, it was drawn back by the significant, rigorous, and effective cross-examination that the defense attorney performed here.
But what effect did the impeachment actually have? I mean, we've all seen or read, not all of us, but many of us have seen or read a million of these impeachments. And at the beginning, what the defense lawyer has is an expert who is saying this hair is consistent with Mr. Redmond's hair and it was found in the bed. And in the end, that's still there. And that's the damaging thing. I mean, we might be like, you're not very, you're a green expert. You've only been working for a year and no, this isn't, we are, nailing down that this isn't DNA. It's not positive. It's not 100%. She admits all of that, but that's sort of where you start, right? She says it's consistent. And in the end, that's still there. The defense isn't able to touch that.
Well, I disagree, Your Honor. The defense asked her, when she testified in cross-examination, it is consistent with originating from Redmond. The defense attorney asked her, because, and I'm skipping a line or two here, but the defense attorney asked her, because some other person or persons in this world could have hair also consistent with the single pubic hair that you found in the bed, isn't that correct? Answer, yes, that is correct. Hairs can look the same. In my experience with working cases, I personally have not seen it, but other examiners in the FBI laboratory have not been able to distinguish two samples of hair. So that is true. And in closing, I'll note that the defense attorney was able to make use of that admission. And the defense attorney argued in closing, what else did Karen Lanning tell you? She told you that she could not, to a degree of scientific certainty, say that was his hair. Why, she said? Because they know in the science that there are other people who have the same hair characteristics. That's what she said.
But aren't they still left with what the prosecutor argued in closing, which is that she said, I only see it consistent in 10% of the cases. So it's not very many. So this means something. And the government is still left with a consistency, right? Which places him there if they want some reason to believe, or, you know, if they're doubting the complainant's testimony.
Well, it places the somebody who has hair that is consistent with the hair that was found on the bed there, and Jesse Redmond is among those who have hair that is consistent with, but we don't know with the hair found on the bed, but we don't know from this testimony how rare that is. I would agree with Your Honor that the 10% testimony was a little bit weird and kind of confusing, and it was a little ambiguous what she meant. I took from that she basically meant, 10% of the time when I'm looking at hairs, I find the two hairs that I'm looking at resemble each other, but that doesn't really tell you, it didn't tell the jury, that anything about an error rate or how rare it is to have two people out there in the world who have the same hair.
But the point that your opposing counsel makes is that as an expert witness, she had the imprimatur of science behind her.
Yeah.
And so anything she was saying in there was presumably more credible, more reliable in the eyes of an average juror. So how does what we saw overcome that?
I think that, experts like anybody, like any other witness, can be cross-examined effectively. And here, again, the trial court found, and this is an experienced Judge DeMayo, an experienced trial judge, she who's, familiar with expert testimony as well as other witness testimony, she found that this cross-examination, even knowing what we know now, and not knowing as much then, but still knowing enough to be able to rigorously cross-examine and point out the limits of the science. The real distinction, I would admit, there are many other others, but the biggest distinction between this case and Jones and Nelson is that in Jones and Nelson, those experts got up and they more or less positively identified the hair as coming from the defendant, and they were not impeached. And this court pointed out in Jones and Nelson, testimony was not refuted, testimony was not impeached. The prosecutor came back and rebuttal and hammered that point his opponent, because that's what they wanted the jury to take back into deliberations.
Yeah, I just
Not what
don't see that's definitely a different case, but I feel like it's only as a matter of degree. Like if the prosecutor is still able to say in the end, only 10% of the time does this happen, 90% of the time, we can't match it. So, here it's matched. What a coincidence or something, why did the government present the evidence? And if it was so destroyed, why are they arguing it in closing?
Well, I agree. I do agree it's a difference of degree. That's what the materiality review is all about. It's the extent to which, and one of the factors in determining the degree to which the defendant was prejudiced by this testimony is the extent to which it was cross-examined, how it fit, and the importance in the case. And again, you look at the ways in which the prosecution was able to use the powerful, unrefuted testimony of these experts in the closing, in the rebuttal, in Nelson and Jones. And that didn't happen here. In rebuttal, I think there was a very brief mention of sort of trying to explain away the fact that the FBI did not conduct mitochondrial DNA testing on this hair, although they had the capability to do it. And by the way, that's another factor that distinguishes this case from Jones and from Nelson, is I don't think there's any mention there about the availability of mitochondrial DNA. But here, Karen Lanning testified, to her credit. I know there's been a lot of invective may be thrown her way. But to her credit, she did testify, look, there is a more useful, another test that the FBI now has the capability to conduct. Didn't at the time they asked me to, but now we do at the time of trial. And we haven't conducted the mtDNA, the mitochondrial DNA testing. And of course, that testing was subsequently conducted, and we know the results of that also included Redmond as a potential contributor, of that hair. So again, I think when we talk about falsity in this context, and in the context of hair testimony, it has to do with the overstatements, not the fact that there's a hair on the bed, not the fact that it's a pubic hair, not the fact that Jesse Redmond is included among the potential contributors. It's the extent to which a jury could take from Lanning's testimony that the hair was consistent with Redmond's, and take from that the hair actually came from Redmond. And the cross-examination here just, completely, I think, deprived the government of the ability to argue that. And they were
It definitely, I agree that it made it just understand, jury, this is not DNA. And she was very honest about that. And, they couldn't have really, she couldn't have said that. I don't think she was trying to say that. I think she was trying to say it was consistent. And I only see that in 10% of the cases, which I think is extremely damaging to the defendant evidence.
Yeah, I don't have any issue with the court taking that 10% statement and just striking it. And we'll be, I am happy to submit the testimony as a 28K letter. Because I know that we were fortunate. The clerk's office actually was very helpful at providing.
We do. Yeah, we have the transcript.
You have the
Yeah,
transcript.
yeah.
Okay, great. I encourage you to read it. It's 21 pages, as we noted, out of 500 pages of trial testimony. And if you strike that weird sort of ambiguous, I think that I'm not entirely sure what the prosecutor was trying to ask that or why they asked that question. If you strike the 10% language, and read consistent with as, includes, it includes Jesse Redmond as a possible contributor, but I can't say, how rare these hair characteristics are, and assess materiality that way. I think that's a fair way to look at this issue. We'd submit to you that, it is not, those particular, to the extent those were overstatements, they were not overstatements that mattered in this case. I want to note one other point, and I'm also conscious that I need to address the Brecht issue. But one other quick
Can I
point.
just interrupt long enough to say, I'd appreciate your submitting the testimony with the 28K letter. I understand we do have the testimony, but we didn't have it upon my first look, and just to be sure that I'm going to get it, I'd like to see it. So,
Absolutely.
sorry to
I will do
interrupt.
that. The other quick point on materiality that I want to make, and just because we didn't draw attention to this case in our brief, but I'd encourage this court to take a look at Hawthorne v. United States. Now, it's not an expert case, but it does involve an eyewitness, and an eyewitness is very powerful testimony. And there was conceded falsities, or I guess this court found falsity in the eyewitness's testimony, but found that the impeachment was powerful enough to effectively mitigate the false testimony that was given there, and therefore found that the error was not material. So I'd encourage this court to take a look at Hawthorne, because I think that analysis applies here too, as the trial court correctly found. With respect to the Brecht issue, let me just sort of provide a little roadmap here. And there's a reason that I'm addressing this issue in the opposite order of Mr. Reiter. And that is, this court has not, it's true that this court has not found that Brecht applies in 23-110 proceedings. And this court, if you agree with us on materiality and find this error was not material under NAPU, you don't need to reach the Brecht issue. It's, however, the way that Brecht works is, this court has, like other courts, have interpreted NAPU materiality as the equivalent of Chapman harmless error. Brecht says on collateral review, there is an additional the proper standard of harmlessness, that is the threshold of prejudice or harm that needs to occur to result in reversible error. That is Kodiakos. That is the actual prejudice standard, which is a somewhat higher, but certainly not insurmountable threshold for a defendant.
Does it mean, I was trying to understand your argument. Do you first, do the more customary NAPU argument and address the reasonable likelihood? I think you all like to say likelihood as opposed to possibility. Do you decide that materiality as the NAPU standard is usually stated, and then you go on to decide kind of a Kodiakos kind of harmlessness?
You could also do what the 11th Circuit did in the Trepal case, which is another case involving an FBI examiner who gave sort of overstated testimony, and you could having found, or having assumed that false or misleading testimony was given, apply Brecht Kodiakos harmlessness, and because Chapman and Kodiakos are both looking at the threshold of harm involved. And this is why in the Brady context, and we point this out in our brief, in the Brady context, you don't need to do Brecht, because the Brady standard for harm, reasonable probability of a different outcome, is already the highest standard. It goes Chapman, Kodiakos, Brecht. For NAPU violations, you're down here at Chapman. So like other constitutional trial errors, you need to take that step up in collateral review to Brecht and apply Kodiakos actual prejudice.
But why would it, the Third Circuit case, I think, talks about Brady and NAPU being two of the kind of exceptions. And why would it make sense? It might be that it doesn't have to make sense. That's what the Supreme Court said. So we're not bound by it in the 23-110 context, but we might, care about what it says, even if it doesn't make sense. But what, if you have a trial and then you don't find out until later that there was, perjured testimony or a NAPU violation, and you go through 23-110, what is the point of treating that differently from a Brady materiality standard, or, having the Brecht protection of the finality and all of that? Does it make sense?
Yeah, I think it does make sense. I think it has to do with the cost benefit analysis that the Supreme Court discussed in the Brecht case. The Supreme Court points out in the Brecht case, collateral review is subject to different and higher thresholds for defendants. It's harder to make a collateral claim because collateral review is supposed to correct the most grievous of wrongs, not to be, a hair trigger reversal of an aged conviction. I note you, Judge Beckwith, had asked Mr. Ryder about sort of giving an example of the Fourth Amendment and suppression. And, that's actually a perfect example, and one that the court brought up in Brecht, because on direct review, obviously, we're here all the time on Fourth Amendment issues. On collateral review under Stone v. Powell, you can't bring a Fourth Amendment exclusionary rule-based claim in collateral review unless you didn't have a free and fair opportunity to litigate it in the trial court. It's a different rule that's less friendly to the defendant, more friendly to the finality of convictions.
Can I ask, I'm sorry for interrupting, but before you turn away from this, I just want to get your explanation of why again we haven't already decided this. And it seems like there's Bagley, there are so many cases in which we have equated the NAPU materiality standard with Chapman. How do you look at our cases and say this is still open to us as a panel, or are you really just saving this for en banc?
I think it's still open. I'm not sure that the government has ever raised this argument. I mean, to be fair, to put my cards on the table here, one of the reasons that I'm making this argument is because in the Butler case in the DC Circuit, where we didn't make a Brecht argument, Judge Katsas in dissent pointed out in the footnote, why isn't the government making this argument. And, you know, I thought made a compelling case. Brecht is a case under 2254 involving review of state convictions in federal habeas. The vast majority of federal circuits have applied it in 2255. The majority of which, not universally, the Third Circuit and the Ninth Circuit are exceptions, but I believe the First Circuit, the Sixth Circuit, the Eighth Circuit, and there's one more I am forgetting, but it's in our brief.
11th, I think. Yeah.
The 11th, yes, thank you. Apply it in the NAPU context. And this court typically looks at 2255.
As the analogy to 23-110.
Absolutely.
Because we don't have actual federal review is, you know, it's sort of like 2255 is like federal courts reviewing federal courts, and that's the analogy here.
That's right. I mean, I think that the Supreme Court in Swain v. Presley said 23-110 is the DC analog, and essentially the equivalent of 2255 habeas review of federal convictions. You know, and I direct the court's attention to United States v. Clay from the Eighth Circuit, which is a case in which on 2255, the Eighth Circuit is applying Brecht to a NAPU claim. But you know, I see my time is up.
But could you, like, why doesn't, I'm sorry, did you answer? You may have answered the question, but Bagley, Jones, you know, Longus, why are those not? Oh, your answer is it hasn't been raised, so it's like we never had the occasion to think of it. But it does seem like it's sort of in the vicinity and it's ruled on, and it sometimes matters.
Well, I think that some of the cases and Longus may have been on direct review. I mean, I acknowledge that Jones was 23-110 case. I think that we're not disagreeing that materiality, NAPU materiality, this court has held is consistent with Chapman harmless error review. Although we do disagree, and this court has not settled who bears the burden on materiality. And we submit that it's the defense because it's an element of the NAPU claim.
But do you, just to interrupt here, do you disagree with, isn't it Chapman that says, and I think it's quoted in Jones too, that it doesn't matter? Who's, you know, whether the government has to prove beyond a reasonable doubt, disprove the harm or prove the harm, I guess. You know, Chapman seems to say that almost categorically.
Well, I think that Jones says in this case, we're leaving that question open. I think Nelson does as well, because in this case, regardless of who bears the burden, it doesn't matter. The DC Circuit, I would note in the Osby and Butler cases involving the same issue, has very categorically said that the defendant bears the burden of demonstrating materiality. I mean, I'm not sure that it necessarily makes a huge practical difference. What I would say is that, you know, with all due respect to my colleague, Mr. Ryder, I mean, I think he put in his brief that the government bears the burden without acknowledging that, you know, this uncertainty caused by the Jones and Nelson cases. We did say that in our brief that, you know, that's an issue that's left open. And so I think that this court, you know, it would be useful and helpful to litigants for this court to make clear, as the DC Circuit has said, who bears the standard of review, and that this is an element of that materiality is the element of a claim, of an NAPU claim, and that the defendant bears the burden to demonstrate it.
But if you think it doesn't matter, should we even reach that question? I mean, you said in your brief that under either standard, you win.
Well, I think that's right. And I think that Mr. Ryder says that under either standard, they win. I'm not sure that it's going to make a difference in a lot of cases. I do think for the clarity of the law, you know, it's helpful to be operating on sort of a shared set of rules here. In terms of, you know, the other quick point I want to make here is that, you know, it certainly does matter on direct review where Brecht doesn't come into the picture, who bears the burden on materiality. And then on Brecht, we're not disagreeing here that we would bear the burden, the government would bear the burden to show harmlessness under Brecht. To the extent that this court agrees with us that Brecht applies, the government bears the burden on Brecht. We're not arguing otherwise, but on materiality, to show, in other words, to show the two elements of an NAPU claim, false statement and materiality, the defendant bears the burden. So unless there are any further questions, we urge this court to affirm.
Thank you, Mr. Hobel. Mr. Ryder, we'll give you 3 minutes.
Oh, thank you, Your Honor. I think at the end of the day, this is not a true secondary review. The discredited testimony was absolutely unknown to the defendant at trial. Now, the United States is trying to say, well, they had extensive cross-examination. Would not a defense attorney have a lot more to say if after this testimony was said by this expert, when she said, you know what, and it's consistent, as the court pointed out, 10%. Ladies and gentlemen, this is just not true. There is no scientific way to prove this. That would have tremendous weight. That's why this is not truly a secondary review. The United States, again, is still trying to play down the importance. That's just not the case here. And it's inherently unfair to any defendant. And at the end of the day, the United States is talking about standards. No matter what decision this court makes, the verdict here is still tainted. And I think the court needs to send a message that when testimony is not true, this is a different type of Brady stand. I mean, it's significant. You did not get a fair trial at the end of the day. Your due process rights were not protected. I did not hear the United States respond to that. And I don't think they mentioned that in their brief. They didn't mention it in their argument. And I think, quite frankly, they have a tough time responding to that type of principle. So on behalf of myself and Mr. Redmond, I'd like to thank the court for its time and consideration in this case, unless you have additional questions.
Only that I want to be sure that I understand what you meant when you said this is not a secondary review. You mean this is not collateral review? Is that what you mean?
Well, it is, but not a traditional collateral habeas review. I mean, usually here's a second bite of the apple. I'm talking colloquially, forgive me, but in fact, that's what this is. I mean, if this had been on direct review, would the court decide it differently? I think so. I think that really puts a defendant or an appellant at a severe disadvantage. That's why this is different. Thank you very much.
Thank you very much. Thank you both for your briefing and your arguments today, and the case will be submitted. The second argument on this morning's calendar is number 22CV299 Romeo Morgan versus DC government DCRA. Whenever you're ready, counsel.
Okay. You ready? Okay, good morning, Your Honors. May it
morning.
please the court. My name is Kelly Baker, and I'm here today on behalf of appellant Romeo Morgan, who is the plaintiff below. Today, Your Honor, I am here trying to help Mr. Morgan preserve the rights in his property. Below, the Superior Court determined that it did not have subject matter jurisdiction over a property tax classification issue. And I argue, one, that DCRA's determination that the appellant's property classification changed to vacant, therefore tripling his tax liability. The fact that it was determined after the mayor's directive during the state of emergency shutdown, that classification is against the mayor's orders. And second, that plaintiffs, I'm relying on the Green case, that plaintiff was not allowed to prove that he did endure exceptional and extraordinary circumstances, which is the reason why he could not go through the administrative process of challenging his tax classification the quote unquote appropriate way. That the pandemic itself, the government shutdown itself, the banks being closed, that in itself is an exceptional and extraordinary circumstances that could not have even been foreseen when Green made this law back in, I believe it was 1973.
So what other do you want to stick on this? Well, what other exceptional circumstances would he have been proving given the opportunity if that basis that you're describing is something that was already out in the public and that we know of, and that you were able to articulate to the trial court?
So the extraordinary circumstance, one is that being in the shutdown, even though we don't have any facts on the record, Mr. Morgan stated he did not even know that a sign was posted on the front of his building because he was in lockdown at home April 12th, 2020. So he didn't receive proper notice. Secondly, he did rely on the mayor's orders that businesses that are shut down from May 11th, 2020 through November 2021 would not have a change in classification to vacant. Mr. Morgan did indeed run his catering business and a takeout business prior to the shutdown.
So let me ask you though, was the change, your basis for saying that changed in April was you're saying that your client, you're saying there was a posting on the property in April of 2021. Is that correct?
Of 2020.
2020. And that is why the status was changed to vacant then.
Well, the posting on April 12th, 2020 by DCRA changed the tax classification from class 2 to the vacant class, I believe class 3.
So why was it not effective back in December when your client was in communication with DCRA and DCRA said, you're granted this vacancy exception on the construction basis for FY 18 and 19, but not for FY 20, you're going to need to file something else, and FY 20 starts October 19. So why wasn't it vacant going back to then?
Well, the construction was complete enough for him to occupy the property. So I do not know that the client took any proactive measures to ensure that the future year that it would not change classifications, but he relied on the mayor's orders that with the pandemic, that there would be no vacant, that businesses would not be deemed vacant during the pandemic. And to Mr. Morgan's credit, he did try to reach out to DCRA. I mean, offices were closed. I did mention that he is a senior citizen. He did tell me he did not know how to get on the computer and try to do anything, but he said he called, he would constantly get that the offices were closed. And so he did save $50,000 and actually paid $50,000 to the tax office, only to find out instead of the normal $45,000 his taxes would have been, is $100,000 to redeem.
Well, counsel, let me ask you, we have in the record that he was in email communication with DCRA. Is that not evidence that he's able to use a computer and email?
I'm sorry, you said you had record that?
We have in the record that your client was in email communication with DCRA. Does that not undercut the point that he's computer illiterate?
I do not recall him mentioning anything about an email, and I haven't seen any emails to DCRA from him.
That was in exhibit, was it B or C? And it's in the supplemental appendix exhibit. There is an exhibit in there where he is confirming receipt of emails. This is in that December 2019 exchange where he was granted the maximum 2-year construction exemption that would lead for fiscal years 18 and 19 that I referenced before, and then told that's the statutory maximum there. He's going to have to file under another basis, and they provided him with instructions for filing a hardship waiver.
Okay, well, that was somebody else helping him. then, because since I've known him for 2 years, have not been able to communicate with him via email. So at that time, maybe he had someone helping him, but during the pandemic, he did not. And my argument today is that in equity, the Superior Court should at least hear the facts to determine whether or not he meets the criteria to not be deemed a vacant classification, and determine whether or not the pandemic itself was exceptional and extraordinary enough, at least to hear his equitable claims. And I believe the fact that he paid $50,000 to the Tax and Revenue Office shows his good faith. That is all he could come up with. He thought he was saving his property, and he couldn't. And so I think this worldwide pandemic, these circumstances, the taking of a business or a property that's been in a family for almost a century, it's just inequitable, and at least the facts should be heard. And I do believe that asking someone to go through an administrative process when offices were clearly closed, that there were people, specifically Mr. Morgan, who weren't given the normal opportunity to access these administrative processes during that time. So I believe that the Superior Court does have jurisdiction with the exceptional and extraordinary circumstance, that it should be heard, that facts should be on the record so that it can be determined whether or not his taxes really should have escalated to $100,000 instead of the normal $45,000.
Let me go back to your leadoff point. You began by saying that Mr. Morgan did not know that there was a sign on the front of his building in April of 2020, I guess. And it sounded like you were primarily going to be making an argument about lack of notice. When did he know that DCRA was taking the position that his property was vacant? When did he learn, if he didn't know about the sign on the front of the
Well,
building?
it is my understanding that within 2 or 3 months in 2020, he did know about the sign at that point, and but he believed that it was an error because the mayor had already determined per the law that any business that shut down during the pandemic would not be subject to any change in tax classification. So to add on to that, even though DCRA may have posted that sign and then he did eventually find out about it, that still in his mind did not click that his tax rate would change, even if he was vacant, since the mayor said that.
But is that the point at which he tried to make contact and failed, or?
Well, yes, he told me that and I just represent to the court, but he told me that the DC offices did not reopen until 2021. So there was nowhere to go, that he did make phone calls to 311 or things like that. And there was no help for him. He said he was familiar with going to Wells Fargo and paying property taxes there, but he wasn't sure if he paid, would it get through? And again, he didn't even know that his taxes had tripled. He was really, during the pandemic, trying to gather the 50,000 he needed just to make sure that when the taxes became due, he could just pay the regular Class 2 taxes. And so he did not know that the actual bill had changed from approximately 15,000 a year to 45,000 a year. So I think that's also the disconnect. Like, should he have been charged triple taxes, even if he was deemed to be vacant, because of the mayor's directive?
Is the mayor's directive in the record?
Yes, I have it.
And what specifically does it say
Okay.
about this May 2020 to November 2021?
Okay,
period?
on page 10, under the first paragraph of the argument, DC code, I'll skip that, section B10, it states that a vacant building shall not be included on the vacant property list if it is a commercial property that houses a business that closed between March 11th, 2020 and November 5th, 2021. And so to deem Mr. Morgan's property vacant 30 days after the mayor has determined that commercial properties that are closed should not be deemed vacant, that in itself should cause the April 12th notice to be void. And even if it's deemed vacant, it should not be charged triple taxes during a time when he personally could not operate his business. Or maybe chose to do so for safety reasons. There are all types of, some restaurants did remain open, but a lot didn't. And his was one of the ones that could not. And so to deal with the worldwide pandemic and the government shutdown and to expect him to somehow operate him or penalize him for not operating a business during this time, again, it's just inequitable. And to take his property by changing the tax classification and tripling his taxes, it's really just inequitable.
So what about the notice of the tax sale? Or the notices of delinquency? When did he get those notices?
Now that, I don't know. I was just told that he did receive tax sale notices and that he said that the DC tax office did not open until October 2021. And he went down there in person to pay. And that's when he realized, well, they wouldn't take his money. They said, well, you owe more than $50,000. And he stayed there and forced to say, I want to pay my taxes. And so he did, the cashier did take his $50,000. And unfortunately, the property still went to tax sale because that did not cover the full amount.
Is it your client's argument that or is it part of your client's set of facts that he didn't go by the business to pick up the mail during the pandemic because he was sheltering at home?
I can't speak to the mail. I believe there was no tax sale in 2020 when we're specifically talking about tax sale. So the first tax sale after the pandemic occurred October 2021. I don't believe that the actual notice went out till August 2021. Or September 2021. So there might have been notices that he was delinquent and that he could face tax sale, but tax sale notices did not go out to him. Like I said, I believe August 2021. So that's when he scrounged to get his $50,000 and again, showed up to the cashier to pay, only to find out it was triple to redeem his property.
Was the notice that you're referring to in August, the August property tax bill that's in the record from August 2021?
Yes, and also I would need to get my file folder, but the actual tax sale notice too, I believe is sent out in August for the October 13th sale. So it is around that time when he actually realized that his property was up for tax sale. And again, he tried to make phone calls. He said that the tax office was not open to the public until October. And when he showed up, that's when he paid.
Now, the property actually was sold, is that correct?
It was, and there's an open case, foreclosure case.
And what is the relief that he seeks? I take it he seeks cancellation of the tax sale of that transaction.
That is correct.
And he seeks a determination that his appropriate amount of tax was not the class 3, is it class 3 tax for a vacant property, but the class 2
Yes,
tax rate? That's
Yes.
the relief he's seeking?
yes, and then his $50,000 payment would cover the taxes owed, and then he would have been in good standing as of October 2021.
What is your argument? The government says, or, cites the standard for determining when equitable relief can be obtained in cases that involve the collection of a tax. And one of the requirements is a finding that under no circumstances could the government ultimately prevail. What is your argument that that is true?
Well, I did not argue that standard, that the government absolutely could not prevail. I argued the standard that in equity, that, let me see, please. That it appears beyond doubt that plaintiff could prove no set of facts in support of his claim. that would show that he endured the exceptional and extraordinary circumstances. So I just believe without any sworn testimony on record or without a hearing, though, that it cannot be determined whether the chances of the government, what their chances are, because there's just been no opportunity to put evidence on the record. And also, I do believe that even if that is statutory, but it is unequitable. Again, this isn't just an extreme circumstance as in Green in 1973. This is extreme in our lifetime. And I think that this is one person with a small business that got caught up in the inability to fully represent himself and do his best to save his property. But he did his best. But in our lifetime, this is just so extreme and extraordinary. I just believe that the Superior Court should at least take findings to determine more rather than just an outright dismissal of the claim, that he does have a right to at least set out the facts and to determine his specific situation.
Thank you, Ms.
Thank
Baker,
you.
and we will give you a few minutes on rebuttal.
Yes, I will observe.
Yes, thank you.
Good morning, Your Honors. May it please the court, Stacey Anderson on behalf of the district and the district agencies. Your Honors, we focused today on the equitable question, whether there's an equitable exception to the Anti-Injunction Act. So I'll start there. What I would like to do is kind of set the table with a overview of the factual background in this case. In 2018, Mr. Morgan began construction on his restaurant, and according to his verified amended complaint, pages 3 and 4 of the supplemental appendix, once construction began, he stopped operating his restaurant for dine-in services and continued his business in the form of a catering and takeout operation. In August 2019, DCRA sent him a notice indicating that it had determined his building was vacant. And in response to that, Mr. Morgan sought exemptions from that classification. He did not argue at that point in time that, no, my building is not vacant. It's occupied by my lawful, validly operating catering and takeout business. So at that point, he essentially conceded his building was vacant. And with that vacancy designation, that designation sticks with the building until the property owner comes back in and shows to DCRA that building is validly occupied. This is a commercial property. We have to show he had a certificate of occupancy for his takeout and catering business. He would have to show that the health department approved that operation while there was ongoing interior and exterior construction at the site. But Mr. Morgan did not take those steps. Again, in response, he asked for an exemption, and DCRA gave him a 2-year exemption for that construction. In December 2019, they advised him that he would need to seek another exemption for 2020. Again, at that point in time, his building had been designated vacant and it retained that designation. In response, Mr. Morgan did nothing. DCRA was more than willing to help him, as indicated in that email exchange that Judge Howard referenced. They provided him with the paperwork for the exemption. They said, it was through email exchange. They said, if you have any questions, please reach out. We're here to help you. But Mr. Morgan simply did not respond other than to acknowledge receipt of that information and documentation. Here he claims that his property wasn't designated vacant until April 2020. There's no documentary support for that in the record, and that would be inconsistent with the statutory scheme, which again indicates that once that designation is in place, it's incumbent upon the property owner to present proof to DCRA that it is validly occupied.
Well, tell me this, they said that they talked about a posting in April 12 of 2020, and I'm not sure where exactly that was in the record. I saw a posting, but it was undated as far as I could see, and looked like that may have been the 2019 posting or 2018. When did he get notice of this vacancy status? Was there anything outside of this email exchange in December 19?
So the notice, the original 2019 notice is in the record. It's at page 25 of the supplemental record. So he received that and he responded to that. In response to that, he returned that piece of paper that he needed to either appeal the designation or request the exemption. And he returned that, and that response is at page 44 of the supplemental appendix. So he was on notice at that point. And as I've indicated, once that building is designated as vacant and that designation is not challenged, it retains that designation until the property owner comes back to DCRA with evidence that it's occupied.
What
Um,
code section says that?
So Your Honor, it's probably gonna be a.
It's in the briefs, I know, but.
Yeah, no, I can, so I would point you to 42-3131.06A1 for the notice that, once it's designated, DCR has to take no further steps and it's incumbent upon the property owner to seek that. I would also point you to the tax code, which also basically provides the same, that once the, I'm sorry, again, I'll go back to 42-3131.16C, which again says it stays on the list until the check classification is approved under 47-813 D15AI2. So, and again, those citations are in the brief. So it is incumbent upon the property owner to do that. And Mr. Morgan did not do that here. So when we get to April, if Mr. Morgan had received a new notice in April, which again, I say is inconsistent with what DCRA's practices in light of the statute, he would have been again told that the steps to appeal or to seek an exemption. If he got that notice, he again didn't respond to that. And the first time he responded in writing, and that's what's expected. There's a form you fill out. And so the pandemic, I don't think he has not said he couldn't correspond with the agencies during the pandemic. He simply indicated that he could not do so through the computer or by phone. So the record shows that Mr. Morgan has experience with this process. He successfully invoked it in the past. And the record does not reflect why he didn't take any steps in 2020 to seek this third exemption. And whether he would have qualified for the one he's claiming now for the pandemic, we would say he would not have qualified for that exemption because his property was not closed as a result of the pandemic. It was vacant in 2018 when he began construction. So it wasn't the pandemic that led to the shutdown. It was the construction on his property. And he has not shown that once that construction started, he had validly occupied that commercial property with his business.
It also
So-
seemed to me.
No,
sorry,
go ahead.
It also seemed to me that you were implying along those lines too, that since the property was already deemed vacant as of this October 2019 date that you argued in your brief, when the fiscal year 2020 started, that also wouldn't apply because it's a new, that is for new vacancies or new determinations of vacancy.
Right. So in October of 2019, at the beginning of the tax year, it was incumbent upon him to seek that third exemption. And so DCRA kind of extended that time out. They didn't actually put him on the vacant property list until April. So they gave him an additional 6 months to come in and show what they anticipated was going to be a request for a hardship exemption. He just simply did not follow through with the instructions he was given.
Is your argument that he knew how to submit written communication, just that he had done it before? Because
That's part of it. Yeah. I
Yeah.
mean, he had been through the process in 2019. He had been successfully, he obtained a 2-year exemption based on that process.
and how do you know how to appeal it? How does it, is it in the notice?
Yes, it absolutely is. Again, Your Honor, I'll direct you to page 25. It goes through each of the steps. You've got to, if you're challenging it, you've got 30 days to get a final determination from DCRA. If they uphold the designation, you have 45 days to appeal to the tax commission. So that's all laid out, again, on supplemental.
And it
appendix
tells you
25.
how to do that.
It tells you how to do that, correct, Your Honor. And it gives you the forms and the paperwork you need to submit along those lines.
So Ms. Baker was emphasizing the mayor's policy that said that that a property would not be put on the vacant property list between May of 2020 and November of 2021. There'd be no change. What's your response to that point?
Twofold, Your Honor. Again, going back to the original vacant property designation, Mr. Morgan did not establish in 2018, 2019, or 2020 that he had a valid operating business from that location. So we would submit that his business was not closed as a result of the pandemic. It was closed as a result of the construction in 2018. Otherwise, he would not have needed an exemption. If he had a valid operating business in 2018 and 2019, he could have challenged the vacancy designation itself rather than simply seeking an exemption, but he essentially conceded that, yes, this is vacant property. And it was vacant at the beginning of the 2020 tax year, where he was told to seek a third exemption. At no point did he claim that, no, I have a validly operating business. So our point is that it wasn't the pandemic that closed a valid operating business that would have entitled him to that exemption, but the business just wasn't eligible for it because it was not validly occupying that property. I guess that's the best way to say it.
Is
And
that,
then-
okay, that's the second point. You
And
said
my-
it was twofold.
Yeah, my second point is he never requested the exemption. So in other words, he never put DCR on notice that he was seeking that exemption, that yes, in fact, my business did close because of the pandemic. He simply didn't put that request in. So he's not entitled to the benefit until he asked for
But
it.
the notice that Ms. Baker read to me said something like, no property shall be put on the vacant property list between May 2020 and November 2021. I probably took really bad notes, so that's probably not what it says, but that's what I recall it says. And
Right.
none of that refers to seeking an exemption or anything, or
Right,
or having or becoming vacant as a result of the pandemic.
sure.
So give me your fuller response to the point about why what happened here is not a violation of that
Sure.
policy.
So a couple of responses, Your Honor. First of all, that's a statutory provision. And that's one of the 10 exemptions that you can seek in response to your property being designated as vacant. So just like all the other 10 exemptions, you've got to request it once you receive that notice.
The notice she read to me is from the statute?
Yes, Your Honor. That provision has since expired, but it is from the 42-31-3106 B10, a commercial property that houses a business that has closed during a period of time for which the mayor has declared a public health emergency as a result of the circumstances giving rise or resulting from the public health emergency shall not be put on the list. So our point with response to that is his business wasn't closed as a result of the pandemic. It closed in 2018, which is why his property was vacant. And then second, even if he might have been eligible for some reason in that intervening period, it was incumbent upon him to come back to DCRA and say, A, my property is no longer vacant, or B, my property wasn't vacant for a period and as a result of the pandemic it closed, it's now vacant, but I'm entitled to an exemption. And he just didn't take those steps.
You say he should come back to DCRA, but I guess in person was off the table for certain points. And
Certainly, Your Honor.
what does he get any? He asserts that he was making telephone calls. Doesn't that amount to a kind of reasonable efforts?
Great. Two responses to that. First of all, the evidence that was before the trial court was that he was making phone calls to the Office of Tax and Revenue, not to DCRA. So he did not, it does not appear from the record that he even attempted to contact DCRA. My second point is he was in email correspondence with DCRA. He had the name of a specific person who said, I am standing by to help you if you need help. So, and he acknowledged that email and he hasn't explained why he could not have email exchanges with that person. And then third, if he actually received that notice in April, he would have been given instructions both on the green placard posted on the building as well as in the written correspondence. And the written correspondence is actually the official notice. He would have been given those forms again to return by mail to DCRA like he did the first time.
And
so-
what is the evidence about his calling OTR? Was that he was confused? He was just calling the wrong place, or was he calling OTR for a different purpose?
So I think he was calling OTR about his classification inclusion on the vacant property list. But by statute, OTR doesn't have any discretion in that regard.
Right, but they
Once-
would have sent him to.
They might have, Your Honor. But again, I say on the history of the case, he was dealing with DCRA extensively in the past
Can I
and
push
should have
back a
known
little
that's
bit
where to
on you
go.
On that, you're saying he was in written communication and we heard your opposing counsel say that someone helped him with the email, someone emailed, and it's true that what the emails show is just a received, like they're generally one word to one sentence responses, but this initial message from DCRA, which is at, I guess it'd be page 67, maybe, from Teresa Hollins, says, "Good afternoon, Mr. Morgan. It was a pleasure meeting you yesterday and having an opportunity to review your concerns. as discussed yesterday and this morning, presumably he was meeting in person or via phone call. It goes through about what he wanted to explore, how they were helping him through with it. And he apparently spoke to the vacant building manager, Donald Sullivan, as well. That I don't see any evidence that he submitted something in writing versus necessarily just saying something to them.
Well,
Where is that?
there is the written response. It's on page 44. So this is his vacant building response form that he submitted. Now, I granted it could have been in person, but I it's a piece of paper that he was given. He could have returned it by mail. So I don't know that he needed to return it in person, although he may have. So again, with respect to that email, I concede that he probably had some in-person exchanges, but the question was it not readily available to him to do so in writing? And that's what the trial court found. The trial court found, look, you've given me excuses why you couldn't go there in person. You've given me excuses why you didn't talk to someone on the phone, but how about just written correspondence? Did you try that? And I think he has a history of that through email. He's received those notices from DCRA in the mail, in writing, and would posit that the pandemic did not preclude that. And I also do want to go back to the point that this was all in December 2019, well before the pandemic. So he, 4 months before the pandemic hits, he's told the beginning 2 months ago, you need to get an exemption. And they gave him 6 months to seek that exemption, and he didn't. And so in our view, it wasn't the pandemic that impaired his ability to respond. He had that 4 months before.
Time running out, I want to move you on to the other
Okay.
agency too, though.
Sure.
So if we go with everything to this point, he knows there's a vacancy. He knows his building's been determined vacant. That doesn't necessarily give us evidence of like his notice of what was going on, or that he understood how that was going to affect his taxes or the tax sale. Where in this record do we get that he knew, should have known, and had an opportunity to respond to OTR's series of events?
Sure. So first of all, I'd say, in looking at the record, I don't know that he made notice an issue. He didn't claim a lack of adequate notice as the basis for his failure to respond. So I'll say that's first. Second of all, we know he received at least one tax bill. And again, in the ordinary course, he would have been receiving tax bills throughout the process. And I would say he would be on inquiry notice if he hadn't been receiving his tax bills for a significant period of time. I just don't think there was the records fully developed on that, because it really wasn't an issue below. But he did say in September, October, he learned about the tax sale. And
Was
so
it really not an issue below? I mean, in his initial pro se filing, he said that he didn't get notice of anything. Both here at argument, we heard that he didn't have notice until September or August at the earliest of the actual tax sale. And then in the opposition to the motion to dismiss both times, there was a lack of notice section. I'm not going to say that it was, extensive, but the absence of evidence is not the evidence of absence.
right. So again, I would go back to the nature of the proceeding here. We moved to dismiss under 12B1 based on subject matter jurisdiction. So the burden was on Mr. Morgan to establish that he had complied with the requirements for that. And if his lack of notice was a basis for him to not have complied, then it was incumbent upon him to present some sort of some sort of evidence. We know that his amended complaint and his opposition are verified. And in those things, he doesn't say, I didn't get any tax bills. He hasn't shown that the notice of the tax sale was out of compliance with the statutory time requirements. It was 2 months before the sale. And I think that complies with the delinquency notice requirements. So he did get that. He just simply didn't carry his burden of proof here to show a lack of notice. And so that, I guess that's our point here.
I have one question which really does not affect the resolution here, but do you happen to know the answer to this question, which is, why is vacant property taxed at such a higher rate than occupied property?
I don't know the specific answer to that, Your Honor, but I would say it's an incentive to either, repair your property and get into a state where it can be occupied. So we don't have blighted buildings within the district. So it's kind of an incentive to force you to do that, or to sell it to someone who is going to make those efforts to make it a usable building again. So I think, to me, that the kind of the common sense explanation I see, but I don't know in terms of the legislative history. If there are no further questions, we would ask that the court affirm. Thank you.
Thank you, Ms. Anderson. Ms. Baker, we will give you 3 minutes for rebuttal.
Thank you, Your Honors. So I would just like to respond first that Mr. Morgan had just gotten finished investing over $100,000 in renovations in the property. So I wish I had pictures, but it had new siding. He was ready to go and get back into allowing customers to dine in. What was confusing about the district's arguments is that Mr. Morgan was expected to, even during the pandemic, expected to still request a vacancy exemption. So he was given the 6-month grace period, but during that grace period, the pandemic happened. And reading Muriel Bowser's directive in the code, it's not clear to me that a business needed to be open and operational on March 10th and then shut down on March 11th to be protected from the vacant property escalation of taxes. It says a commercial property that houses a business that closed between March 11th, 2020. Even if Mr. Morgan was closed, he couldn't reopen, or he didn't have the infrastructure to reopen. And I argue that he still falls within the district's protection for commercial properties that were not open during the pandemic. And so I think it's confusing to hear pre-pandemic remedies and offers to Mr. Morgan, and that he was still expected to do those things post-pandemic with certain protections. And again, extraordinary circumstances that came along with the pandemic. This is, again, a business that operated for almost 100 years. He wanted to be in business. He wanted to serve customers. He wanted to renovate and improve the property, which he did. And so my argument today is that this circumstance is extraordinary enough. And I think the good faith effort for him to pay $50,000 to the district and the renovations that are in the property, for him to lose his property right now, his family to lose the property right now, it's just inequitable. And I believe that he should be heard in court to put on further evidence to determine notice, to determine good faith efforts.
So just to be clear, because I've read one argument in the briefing and below, and I'm hearing something slightly different here from you in this rebuttal. Was the business closed or opened when the pandemic came on?
Mr. Morgan presented to me that the kitchen was still operational and that he operated a catering business continually, even during the construction, because the majority of the construction was exterior. He had some type of grant received from the city, as well as some of his own funds. And so he was actually investing in the facade of the business. So the kitchen equipment was still operational, and he was operating catering only and takeout only up until the pandemic.
Does that mean the exemption that he had for those 2 years was the wrong one then?
It appears that way. I think it sounded like that was because he said he was questioned. He was harassed by neighbors who said, we want your property, sell it to us. And so he believes they made a phone call to report him as vacant. And so he said he did provide utility bills and different proof that he was still operating. And it sounds like it was the easy route to just say, fine, we're doing this construction. We'll just do the construction exemption. Get off my back, please. So that is a possibility as well, that the exemption that he chose to take was because of the construction, even though he still had an operational kitchen inside.
And also, just to be clear, in your initial argument, you alluded to this, but it's your position that he was financially incapable of redeeming the property, paying the rest of the taxes to bring while he brought suit.
Absolutely. The $100,000 that was due prior to tax sale, he only had the $50,000 that it would have been if it were not for the tripling of the taxes during the pandemic. Okay, thank you so much.
Thank you very much, Ms. Baker, and thanks, Ms. Anderson, for your arguments today. The case will be submitted. Third argument on this morning's calendar is number 22 FM 498 In re Diana Dutton.
May it please the court. Jennifer Williams, on behalf of appellant Diana Dutton, I would like to reserve 2 minutes of my time for rebuttal. The evidence at trial did not support either of the court's grounds for ruling that Ms. Dutton is likely to injure herself if not involuntarily hospitalized. First, because Ms. Dutton is a small 80-year-old woman who is obviously sick and is never physically aggressive. It is unlikely that her name calling and verbal hostility when agitated would provoke violent retaliation in the community. And second, the evidence did not support the trial court's alternative ruling that involuntary hospitalization was necessary to protect her from the threat of heart attack or stroke, because as the evidence showed, the trial court found and the government concedes, whether Ms. Dutton is in the community or not, the threat of her suffering a heart attack or stroke remains high. And thus involuntary hospitalization does not eliminate or substantially lessen the risk of this injury. The trial court's ruling was unsupported by the evidence, and thus this court should vacate the commitment order.
Is the question whether she would suffer a stroke, or is it broader, like whether she'd be in a safer place if it happened? How concrete does that have to be?
So the trial court's finding wasn't sort of about anything to do with whether she was going to be in a safer place, whether, emergency response teams would get to her more quickly at St. Elizabeth's. It was specifically that if she goes off of her medication, she will be at risk of heart attack or stroke. And the trial court also made findings that at St. Elizabeth's, she is at risk of heart attack or stroke. And so there is no basis for finding that, involuntary hospitalization will substantially improve diminish the risk of heart attack or stroke.
Before you launch into your argument, I wanted to ask you this question. Maybe you can help me understand what it means to have a commitment order. I noticed that the Superior Court's order says that Ms. Dutton is hereby committed for a year for inpatient treatment. And then the next paragraph, or the one following that, says something like, but if she should be discharged for outpatient treatment, then she shall cooperate with outpatient treatment. And that got me to wondering, what does it mean to be committed for inpatient treatment? Because it sounds like it's up to someone else other than the court to decide whether she should be treated on an inpatient or outpatient basis. What's your understanding?
So my understanding is that there exists a continuing obligation that if at any point Ms. Dutton is no longer in need of involuntary hospitalization, that her treatment team would have the ability to discharge her to outpatient commitment if they felt that she could safely live in an outpatient environment. So I'm assuming that sort of discussion in the commitment order is recognition of the ongoing obligation to allow Ms. Dutton to make sure that Ms. Dutton is in the least restrictive treatment environment capable of protecting her from harm.
So would it be fair to say that her challenge here is to the order of commitment, be it inpatient or outpatient, or is she specifically challenging commitment for inpatient treatment?
So Ms. Dutton maintains that they did not meet the burden to establish that any kind of commitment is appropriate because they have not established that she would be unsafe to herself in the community, either because of retaliation or because of the possibility of a blood pressure spike.
At some point during the hearing, and I wanted to say during the trial, but to be honest, I'm not sure whether it was the hearing before the commission or the trial court, you can correct me, but at some point, her counsel said that St. Elizabeth's had not explored alternatives, less restrictive alternatives, such as counsel said, a nursing home.
Yeah.
So is it her position? Well, I guess what I want to ask you, when I asked the question about what it is that she's challenging, it was sounding from that statement that she would not have challenged or possibly would not have challenged an order of commitment to a nursing home, just that she was challenging inpatient treatment commitment.
So we think it's very clear from the record that it's essentially conceded that they did not explore those sort of alternatives like, a memory unit or a nursing home. But Ms. Dutton's position on appeal is that they did not meet the standard for any form of.
For any
commitment.
kind of commitment.
Yes.
And one other preliminary question, if you're able to answer, is what is it that is more restrictive about inpatient hospital treatment? And by that, I mean more restrictive than, say, nursing home treatment.
So-
Is it that the record tells us, for example, that in a nursing home, there is no ability to forcibly medicate? Is that what makes it more restrictive, or is it something else? Because they both sound pretty restrictive, quite frankly.
We would agree, and Ms. Dutton agrees, which is why her position is what it is. And admittedly, I have not spent as much time at St. Elizabeth's as some of my colleagues at the Public Defender Service. But my understanding is, and I would say that they actually don't know whether or not nursing homes can administer medications, sort of involuntarily. The reason that Ms. Dutton's medication is administered sort of against her will is because she has a guardian who authorizes her to receive these medications. And so he could, there's no reason to think that he couldn't also authorize these medications at a nursing home. I don't think that there's any sort of meaningful distinction between those two spaces that make it so that you can do that at a hospital, but you can't do it at a nursing home, or at least that wasn't established. But Ms. Dutton's movement is completely restricted at St. Elizabeth's. She exists on a unit where she is in the company of other civilly committed individuals, and sort of many things about the way her life, basically everything about how her life moves is controlled by the staff at St. Elizabeth's. I'm going to bite my tongue if I say this incorrectly, but I think it's for the most part, it's a locked unit. I don't think she has, unless she has earned these liberties, the ability to, go for walks and other things like that, things that you would expect to see at a nursing home where I think and again, this is just my subjective understanding of nursing homes versus my limited understanding of St. Elizabeth's, but her control over, and she has very little agency at St. Elizabeth's versus what she would experience, I think, at a nursing home, and certainly what she would experience if she was allowed to live freely in the community as she wants.
Thank you.
So the trial court did not establish a likelihood of retaliation based on Ms. Dutton's speech, because we know that when you're considering whether or not there is specific speech is likely to provoke violent retaliation in others, you have to take a very context-specific approach. The court sort of invoked the doctrine of fighting words, and we think it's sort of a useful analog because the question there is very similar to the question here, whether or not there's a likelihood of violent retaliation based on, pure speech. And that doctrine has just been sort of eroded and limited to very specific circumstances in acknowledgement of the fact that it is very unusual for speech to provoke violent retaliation in people. And when you're deciding whether or not speech is going to do that, you have to consider the personal attributes of the speaker, and you have to consider how they're saying their speech. So what they're saying, how they're saying it, and who's speaking. And here, although the court was very focused on the offensive nature of Ms. Dutton's speech, if you look at the other characteristics about Ms. Dutton, it sort of undercuts any finding that violent retaliation is the likely response. You have the fact that Ms. Dutton is an 80-year-old, small, frail woman. And when she's speaking, it's pretty clear that she's in an acute state of emotional distress, if not mental distress. Most people who have seen her have, or basically everyone who has seen her have one of these episodes, has essentially determined that she appears to be mentally ill. And then you also have the fact that multiple witnesses have said that she is not physically aggressive when she's doing this. And so Ms. Dutton is a part of a class of people who are already very unlikely to be violently retaliated against, because we as a society don't really go around hitting elderly people because we have sort of protective feelings towards this class of individuals.
So can you clarify, and this may get in a little bit to the disputed evidence, but there was questioning of, I think Dr. Zaidi, I think about information he had about a prior incident where your client, had someone attack her or retaliate against her. Is that, how much of that, if any, is in the record, and what is, where do you put that in the response you're giving to Judge Thompson?
So that is in the record only in as much as Dr. Zaidi said that Ms. Dutton had been retaliated against. He cited one incident, and then he later said in a sort of conclusory way 2-3 times, but with no details. So the incident he focused on was Ms. Dutton falling over and breaking a hip after she was struck by another patient. And he said that this was in retaliation for her speech. On cross-examination, counsel sort of pointed to, he had named specific records as the basis for this information. So he was basing it off of hearsay, which an expert is permitted to do only to the extent that it informs their opinion. And he was cross-examined on the specific pieces of records that he claimed were the basis of his knowledge that she was retaliated against. And he had to admit that in none of those records did it say that Ms. Dutton's, this sort of altercation was provoked by Ms. Dutton's speech. And so ultimately, that it seems that that argument was somewhat abandoned. The government didn't try to rehabilitate him on redirect. They didn't argue it in their closing, and the trial court didn't make the finding of retaliation. So, and even if they had, frankly, his evidence, his sort of recounting of this incident is not substantive evidence that she's ever been retaliated against.
Counsel, and would you agree that if she was retaliated against there in the hospital, that's a meaningfully different population than who she would be with outside of the hospital?
Yes, Your Honor, we would absolutely maintain that sort of a psychiatric unit that's designed for people that are in acute mental distress is very different from the sort of people that you would expect to see in the community, or at least that the government put on evidence that you would see in the community.
Well, I wonder about that because, the record discloses that at some point, Ms. Dutton was brought into treatment because she was lying on the floor at Union Station, yelling obscenities at people. I've been to Union Station lately, and there are a lot of homeless and seemingly mentally ill people at Union Station. So I'm not sure it's true to say, or that we can assume that who she would encounter in the community would be different from who she encounters in St. Elizabeth's. But in any event, I wanted to ask you about that because you're quite correct in what you said earlier, that it was the trial court that invoked the phrase fighting words. And your brief cites that and then talks about the case law under the First Amendment, which uses a sort of a reasonable person, average person standard for determining whether words would be of the sort that would provoke violence. I wonder whether that's the standard we ought to apply in this context. This is not a case that's about somehow punishing her for using certain words that are fighting words. This is not a First Amendment restriction. This is a case about whether or not there's an adequate basis for believing that she would be at risk of injury if she were in the community because of her yelling obscenities and the like. And so I'm not sure that the average reasonable person standard applies. And to get back to Union Station, she might well encounter out in the community some people who are not your average reasonable person, who might well respond to her hurling obscenities with violence. That appears to be what the record says about some of her peers in St. Elizabeth's, who in a couple of places in Dr. Zaidi's testimony, he referred to, actually he referred not only to the progress notes by nursing staff, but he said he had spoken to her treatment team, and he noted that he had heard from Dr. Lacey, I think was the name, about her being moved because of retaliation. So I don't know, I'm not sure I'm persuaded that the record is without substantial evidence that Ms. Dutton's behavior would not likely cause her to be victimized because of her hurling obscenities at people. So that was a lot in that question, and I apologize, but
No.
what's your response?
It's an important question. So multiple responses to your first point, Your Honor. As we have already sort of all acknowledged, the trial court's finding here was that it was not that Ms. Dutton, she has these very offensive tirades, and most people are not going to retaliate against her, but she might come across some people either at the shelter or if she's living at Union Station who might want to retaliate against her. And so I'm going to find a likelihood of dangerousness. The trial court's finding was this sort of embracing this more objective, generalized statement about the fact that her words are the kind that will provoke people, others, to retaliation, are very likely to induce violence and retaliation, was the words of the trial court. And this court is reviewing the trial court's finding. But another important piece is the trial court didn't make a more specific finding because that wasn't the argument that was presented by the government. The government didn't put on any evidence that Ms. Dutton, when in the community, is going to be exposed to individuals that are sort of uniquely likely to violently retaliate against her. And so we have to consider that as a part of its analysis. And so if the court were to reach beyond the actual evidence that was presented by the government, it would be sort of getting close to this speculation that the court said is impermissible for due process reasons in Mendoza. And then on top of that, Your Honor, I think it's important to think about what it is when you're assessing a likelihood here. And the fighting words context has sort of dealt with what you're talking about. When it says there's a number of cases that say it is maybe conceivable that someone is going to retaliate against this person based on this speech, but that is not sufficient to establish that it is likely someone is going to retaliate. The existence of possibilities or of, I think in the case California v. Cohen, they talk about people of violent and lawless proclivities who might be moved to violence by the words that a person is saying, does not establish that the person's words are likely to cause retaliation. And I think your word choice, Your Honor, was might well. The people at Union Station might well respond with violence to her. And that is not, as a matter of law, sufficient to establish a likelihood.
Well, that's an interesting point. I have to say I've been thinking about, and it's a little confusing. Our case law is a little confusing because we have the Peruso case, which I know you're familiar with. It's been cited in the briefs, and it says something like, I won't get this quite right, but something like the injury requirement, likely injury requirement is easy to establish. But then there is the clear and convincing evidence standard. And then there is the Lomax case, which talks about it being very difficult to project behavior. So I find it difficult to know which one of these standards we ought to be applying when we think about whether Ms. Dutton is likely to injure herself if in the community because of her behavior and her yelling at people, et cetera.
Absolutely. And Your Honor, I think the answer there is, I think perhaps maybe my hope is that the Peruso court, when they said that, we're talking about the fact that we have a pretty expansive definition of what constitutes injury in this jurisdiction. We sort of allow for a lot of unforeseeable scenarios that could, to some extent, cause a danger, and all of those are available as possible injuries. But I don't think the court could have actually been saying that this is a really easy standard to meet, because it is absolutely not. And the Supreme Court has said under Addington v. Texas, and this court has said that we're talking about a exceptional deprivation of liberty. There's a case that's cited that I think is instructive here. Covington v. Harris, I think it's also cited in Mendoza. And the court there says, this is an extraordinary deprivation of liberty justifiable only when the respondent is mentally ill to the extent that he is unlikely to injure himself or other persons if allowed to remain at liberty. A statute sanctioning such a drastic curtailment of the rights of citizens must be narrowly, even grudgingly construed in order to avoid deprivations of liberty without due process of law. And so here you're right. The standard is clear and convincing, which means that this court has to have a firm conviction without hesitancy that Ms. Dutton is essentially, there is a high chance, or a very probable outcome is that Ms. Dutton is going to be retaliated against. We would maintain that essentially this court has to find that it is more likely than not that Ms. Dutton is going to be retaliated against. And so if that is the standard and that is the degree of certainty that the court has to have constitutionally under Addington v. Texas, that is not consistent with sort of an exploration of all the hypothetical scenarios not presented by the government that could put her in harm's way. And another thing that I think is important in the civil commitment context, apologies, Your Honor, I saw you on the beginning of it.
No, I'm with you. Thank you. These are difficult points, I think.
Another thing that is true in the civil commitment context is that the danger productive behavior has to be based on mental illness. So, you know, the reason that Ms. Dutton is in danger in the community has to be her symptoms. And so if you're talking about someone who perhaps for mental illness reasons has lowered inhibitions and is more likely to be violent, or someone who is, you know, a opportunistic mugger who is looking at Ms. Dutton and saying, I'm going to attack her. She is not the reason that she is in danger. Her symptoms are not the cause of that dangerous scenario. And there has to be a tightness between the danger productive symptoms and the sort of peril that Ms. Dutton would be in the community, particularly in a case like this, where we're talking about fighting words, we're talking about the First Amendment, and we're talking about potentially taking away someone's liberty on the basis of speech. And if
Right, but we're not trying to restrict her speech. That's why I think this is really quite different from the analysis in those fighting words cases, even though I think the trial court's use of the phrase fighting words clearly was taken from those cases. And you are certainly correct that there is another point here, and this is part of the argument in your brief. There's a question about whether or not the yelling of obscenities is because of her mental illness or something else, like
Yes.
dementia, for example. So there are a lot of issues floating around here, but it seems to me just as a logical matter, even with a clear and convincing evidence standard, some things are more easily proven than others. It just seems to me that as to some things, one could reach the kind of certitude you need for clear and convincing evidence with not a lot of evidence, whereas with respect to other things, maybe not so much. And I don't find it so difficult to believe that hurling obscenities at people, especially if some of the people are not your average reasonable person, but others in the community, that injury and retaliation would likely follow. But, you know.
So, Your Honor, I think that it is sort of important also to look at, this court is reviewing the ruling that the trial court made and the findings that the trial court made. And that is just not, that's not in the case. We understand that the government sort of made that argument in their brief, I guess, to sort of try to bolster the reasonableness of the trial court's determination that there's a likelihood, but it was not in the evidence presented. It was not in the findings found, and it was not the nature of the ruling that the trial court made.
Right. Although I think that I'd have to go back and look at it, but I don't think the trial court's ruling was specific to who it is that might retaliate. It was that her behavior was likely to cause retaliation. You're quite right. I mean, the court didn't say it might be other mentally ill people in the community, or it might be the average reasonable person. The court did use the phrase fighting words, but I'm not sure it meant to import all of that First Amendment case law.
That is true, Your Honor. But I do think that, you know, for the factual reasons, the way this case was presented, and then also just for the fighting words context gives a good window into how you establish a likelihood. I mean, sort of setting aside the sort of burden of proof, they're talking about when things are and when things aren't a likelihood, and they all accept the notion that possibilities of things cannot be a likelihood. There's another sort of analog that could be useful is the Cross v. Harris case, which discusses the sexual psychopath law, which has a similar sort of determination of when things, you know, a likelihood of future injury. And in that case, you know, the majority was sort of responding to a dissent argument that, you know, we have to consider the possibility that when, you know, these things happen, children, small children could experience psychological trauma. And the majority in that case said, we acknowledge that possibility. That is certainly a possibility. But whatever, a likelihood is, a possibility is not a likelihood. And so I think that looking at any analogs that have addressed the question whether specific speech or specific behavior is going to lead to an injury, all of them reject this notion that possibilities or hypothetical scenarios can support that finding. So we believe that the court did not establish, because of that, a likelihood of retaliation. Also because even though, you say her offensive speech shouted at people is going to provoke retaliation, you really do have to think about the fact that Ms. Dutton is an 80-year-old woman. And I don't know what kind of people we're imagining here. You sort of can spin out a lot of different kinds of people. Perhaps there are people who would attack an 80-year-old woman, and perhaps there are a lot of people who are mentally ill who would not. But the fact that she is a person in that class who is just fundamentally non-threatening. She's not someone who you would ever take as a threat, even if she's saying things that are deeply offensive. And so in that kind of situation, it's just very difficult to imagine the court getting to the degree of certainty that they need to of a likelihood of violence against her. So if there are no more questions on that issue, and I can turn to the second issue.
Okay. We'll give the government some extra time too.
Oh, man. And I see that my time is up.
Yeah, go ahead.
My
Well, we
apologies.
would like to hear on this one too.
I would just like to say that there was no evidence or finding by the court that continued sort of detention commitment at St. Elizabeth's is going to substantially or even in any way improve her chances of not having a stroke. The court found that she will be at risk of heart attack or stroke if she is in the community and off of her blood pressure medications. The court also found that at St. Elizabeth's, she is at real risk of having a heart attack or stroke because of the experiences that she has there. The evidence is that her blood pressure remains high even when she's on the medication. And so without any evidence that being at St. Elizabeth's is going to substantially reduce her risk of having this sort of catastrophic medical complication, you cannot justify depriving her of her liberty. So I will leave it at that. Thank you.
Thank you. And we'll give you some time on rebuttal. Whoops.
Good morning, Your Honors. May it please the court. Eric Levine for the District of Columbia. So I want to start, because this is a sufficiency of evidence challenge, just laying out all of the evidence supporting the fact or the finding that Ms. Dutton is likely to injure herself. So I see there's sort of 4 or more general categories that this evidence falls into. So first, there's the evidence of direct retaliation, the direct evidence of retaliation. Those Dr. Zaidi testified to multiple instances when Ms. Dutton was assaulted, including on SA 31 by another patient who shoved her and fractured her rib. The second category I would call threats. These are statements Dutton made, including threatening to shoot people, to take them down, yelling things like "I'll fuck you," and her consistent threats to harm Dr. Zaidi whenever he tries to complete a diagnosis. This category is important because of a recent opinion in Ray Gaskins, which we can discuss later. The third category are the targeted, vulgar, and bigoted insults. These are things like she said to a Muslim psychiatrist, calling him ISIS and telling him to, quote, "get out of our country," along with homophobic insults, referring to people as homosexuals in a derogatory way at shelter staff, which is consistent with how she treats her fellow patients at St. Elizabeth's, calling them lesbians, sluts, and
why doesn't this cut against you, where you're noting all of these, very offensive things she's saying, but no one is attacking her?
Well, in the first category, there is evidence that she was directly
Besides
retaliated
that, yeah.
against. And second, we only have to prove that there is a likelihood that she will be retaliated in the future. And sort of the case law, as this court's mentioned, it's only In interpreting the Irving Act, this court has made clear that the risk of injury requirement is easy to meet in that the danger does not need to be physical or nature or involve violence. It can simply be that inducing violence in others is sufficient. That's the In re Bumper case. And that all that is required is to inadvertently place someone in a position of danger. So what I'm trying to demonstrate with these categories are, these are all separate ways in which Ms. Dutton's mental illness and her behavior acting in accordance with that places her in a position of danger.
Can I ask, the first one you mentioned where she was injured, what is the tie? Can you describe the link between what happened to her and her mental illness?
In the category of direct retaliation?
Yes, the first one.
So Dr. Zadie testified that as a result of her insults, she provoked, and this is again on essay 83, her insults provoked a fellow patient into shoving her and fracturing her rib. And that was sort of one specific instance that he talked about, but he said that there was at least one other. And that is, again, getting to direct evidence of physical retaliation, which we do not have to prove. We only have to prove below that all that's required is, again, that they'll be put in a position of danger. And so, again, the threat
there too on that likelihood. Then there was some testimony on the record that Ms. Dutton likes to isolate herself and that she doesn't get aggressive with individuals until she's interacted with. Is keeping her in a involuntary commitment forcing her to be around folks and interact with her more than she would if she were free and out amongst the public?
No, and I think Judge Thompson's questions on this matter about who she's likely to encounter in the public is really key there. So if we look to sort of my third category, which is other aggressive behavior, the Union Station incident is key on there. In that instance, we have Dutton throwing herself on the ground, blocking the main entrance to Union Station. And anytime anyone's trying to get by her, she's cursing at them, calling them bitch, motherfucker.
Counsel, this was after she got mugged, right? As your opposing counsel pointed out, this wasn't a regular incident that was brought on by her normal mental illness that we would regularly expect, correct?
Well, I think the record supports that it's as a result of her delusion, and that she was deluded about the fact that she possessed some evidence that the 2012 election was overturned, and her action was then taken in accordance with that delusion, in that she was trying to get her phone back or raise awareness about it. And so that's sort of, if we sort of sidetrack there, in re Peruso, in that case, this court held sufficient to uphold a finding of likelihood of injury just on the fact that that person was having delusions and acting on those delusions. So that's a separate instance there where this court could affirm the finding of likelihood of injury, and that Ms. Dutton's mental illness puts her in a position of danger because she is having these delusions, and the record supports that. And she acts upon them. So, but to continue on with sort of behavior and describe the scene at Union Station where she is cursing at people, as I mentioned, when police tried to redirect her, she continued cursing at them. And then when the Department of Behavioral Health official arrived on the scene, he said that people were beginning to aggressively, verbally retaliate, and that he filled out an FD-12 form to commit Dutton on an emergency basis, because if he did not, something like that, referring to physical retaliation, would happen. So this is a person who's observing the circumstances at Union Station and believes physical violence will occur. And so that sort of counters my friend's position that age and frailty were not considered, because when the trial court credited that testimony of a then 76-year-old Ms. Dutton, that implicitly sort of recognizes that that is a factor that's being considered. So the that was the other aggressive behavior is my fourth category. The third one was those targeted bigoted insults. I'd also like to add the fifth category gets to that delusion that I was mentioning with you and acting on that delusion. And then sixth, and this is an independent basis that the trial court found for Ms. Dutton suffering putting herself in a position of danger, deals with her inability to manage her blood pressure if she were to be released and stop taking her psychotropic medication. The evidence shows, or the record supports, that if she were to stop taking her psychotropic medication, she would decompensate, lose the ability to concentrate, become so disorganized, she would be unable to either take her blood pressure medication regularly or manage her numbers. And this is a key with blood pressure, because it's important to know on a day-to-day or week-to-week basis to know if your medication is at the proper level to even know if it's effective. And the record supports that Ms. Dutton would be unable to really manage her blood pressure, which is very, very important.
What in the record supports that?
Dr. Zadie's testimony on cross-examination was discussing sort of the blood pressure. I can find a site for you. I believe it's SA. I don't have that handily for me. But there is record on cross-examination that Dr. Zaidi was talking about comparing blood pressure to diabetes. That's important to manage your numbers.
What about when she was in the community before? Isn't there evidence that she did okay with her regular physical health? Even if she didn't take her psychiatric meds?
I mean, I disagree with that characterization, pointing to the third FD-12 form that was filed in December of 2019, which led to her commitment. In that circumstance, Ms. Dutton was confused and really unable to communicate and was experiencing physical discomfort and had to be hospitalized as a result of that. So that sort of cuts against the notion that she's able to manage herself well in the community.
Those incidents were, after months of no incident, right?
No, Your Honor. The third FD-12 form was less than a month after she'd been released from St. Elizabeth's after her commitment following the Union Station incident. So there's less than a month that she was able to successfully take care of herself. So she's got to demonstrate a record of her inability to do that.
Is it your position that the blood pressure point would have been enough to justify the commitment order? Let's say there were not the evidence of Ms. Dutton hurling obscenities at people and putting herself in danger because of that. Suppose all there were is the evidence about how if she doesn't take her psychotropic medications, she becomes disorganized and she won't take her hypertension medication, and she will put herself at risk of, I think Dr. Zaidi listed several things. I think the trial court mentioned stroke and heart attack, but he also mentioned kidney disease, blindness, all the things that high blood pressure can occasion. Suppose that's all there were. Is that enough to justify a commitment order?
Yes, Your Honor. The reason for that is sort of twofold. One, it's sort of she's not taking her blood pressure medication as a result of her mental illness. And when she experienced her episodes, the record is clear that her blood pressure spikes as high as 192, which is extremely dangerous. And Dr. Zaidi has said that if she fails to continue taking her psychotropic medication, those delusions she'll quote, become more psychotic, and they're going to get more intense. And that's on SA 100. So the sort of on the blood pressure issue, why that's important is because she will become more agitated, more frequently have those very, very high dangerous spikes up to 192 if she were not taking her blood pressure medication or psychotropic medication.
What about the argument that she seems to have developed this blood pressure problem since she was at St. E's, and that there are a lot of triggers to it there? And so, how do we really know by clear and convincing evidence that she's better off there rather than out in the community?
Yes, Your Honor, we do. I would direct you to the 2018 FD-12 incident, as well as the Union Station incident, to show incidents of where she gets agitated in the community. And to get to Judge Thompson's point earlier about people she would encounter in the community, there's all sorts of agitators in the community. And St. Elizabeth's is a restricted, controlled environment where she has 24-hour monitoring. So this notion—
It sounds like she has daily, maybe many times a day, contact with the sorts of people who make her, provoke her. People are trying to treat her psychiatric illness, where that wouldn't be true out in, she may encounter people, but not that often, right?
Well, I think that that's relatively speculative. We are looking at, she has incidences at the shelter again that led to the FD-12 form. She was there for, I believe, 5 months and had the Department of Behavioral Health call on her twice in that time. So this does establish that she does have these episodes in the community.
Well, let's get to the issue about whether or not it's her mental illness that was causing her behavior that puts her at risk. As you know, there's in your opponent's brief an extensive discussion of the fact that she was referred for neurological testing and I think she did finally, after the trial court ruled, the court was informed that she had, I guess, an initial MRI, and there was evidence of some possible neurological deficit. Maybe dementia is mentioned in the briefs. How could the trial court determine that it was Ms. Dutton's psychiatric problems, her mental illness that is the cause of her behavior and not something like dementia?
So the record does support that it is a result of mental illness, and I direct this court to SA 107 to 109, where Dr. Zadie talks about how not all of Ms. Dutton's symptoms could be explained by something like dementia.
He
And
says
in
her
particular-
delusions are
Correct.
not explainable by that.
Correct. Particularly the delusions of grandeur, which is that more specific one to a mental health diagnosis there. And that could not be explained by dementia. Further, it's not in the record, the MRI results. And I'm not a doctor, but I've been told that interpreted subsequently that they have ruled out dementia as an issue, if this court is concerned about that at all. But that, again, that was not in the record, and that is just sort of what I've been told and how to interpret the results. Getting to, I guess, the issue of the blood pressure, I guess the blood pressure medication, again, it is Dr. Zadie's opinion that Ms. Dutton will decompensate to a degree that she'll be unable to care for herself with regard to her blood pressure medication. That is an independent basis on which this court could affirm. But I want to make something very clear. All this evidence that we've been discussing so far, in order to reverse, this court would have to weigh all of that together when viewed in the light most favorable to the government, and conclude that no reasonable jurist could conclude that Ms. Dutton is able or puts herself in a position of danger as a result of her mental illness. If the court has no further questions.
I have one that may not be necessarily related to the outcome, but you know, unlike in the Peruso case, this court talked about having someone committed and under treatment until they reach an optimally stable point. As I look at this record, I don't see, is there anything to you or any determination on your end that there would be an optimally stable point that Ms. Dutton could ever be expected to reach if we were to go along these lines?
Yes, there is. And I believe this gets to Judge Thompson's questions earlier about inpatient versus outpatient treatment. So the least restrictive means here is inpatient treatment because of that voluntary or the involuntary medication order. And there's evidence in the record to support that outpatient treatment facilities simply do not have that capability. And you're talking about a difference in kind of treatment. So if Ms. Dutton were to improve on her medication to a degree such that she no longer needed to be involuntarily medicated, then that would be a situation when this order would transfer to an outpatient treatment. And if you look at the commission hearings, that's actually the original recommendation by the medical team was outpatient because they didn't have that information, that key information that outpatient facilities lack the capability of doing involuntary medication.
There's a footnote in your brief where you tell us that this case is not moot, even though the commitment order expires in early June, because of you cite some cases that mention the collateral consequences of commitment orders. And I think you also mentioned the capable of repetition but evading review point. I guess I see that point, the capable of repetition but evading review point. But is this really a case where we worry about collateral consequences? This is a litigant who has had previous commitment orders, and she's 80 years old. So the usual collateral consequences that we worry about, arguably at least, don't apply here. I mean, she's, you know, I suppose she could be applying for jobs at age 80, but I hope I'm not applying for jobs at age 80. And she already has, you know, a history of mental illness determination. So is that applicable here, the collateral consequences point, or is it just the capable of repetition and evading review point?
I'm not familiar with the specifics of that argument. I apologize to the court for that. So I don't want to make any misrepresentations. I do believe it's that our position is sort of generally that it is sort of these stigmatization types of things that are the collateral consequences of such an order. Any other questions? All right, the district just asks that this court affirm.
Thank you very much. Ms. Williams, sorry, we'll give you 3 minutes, but
Apologies, briefly, your honors. So first, just to the sort of likelihood of retaliation question, I think it's really important to focus in that inquiry on what the court found, what this court has said about, the factual findings of cases. The bottom line is that as an appellate court, we do not make findings of fact, and therefore we may not rule on our own reading of the evidence unaided by the trial court's findings, because the findings of the trial court reflect the legal significance the judge attributed to particular facts and make it possible for the appellate court to determine whether the judge correctly applied any presumption of law or used appropriate legal standards. So in a case like this, where you do not have any findings by the court, Ms. Dutton is going to live in Union Station and see a lot of people who are mentally ill, or see a lot of people who are potentially violent, or live in a shelter where those people might also be residing. You can't, and the trial court's finding is embracing this more objective ruling that Ms. Dutton's speech is just the kind of speech that causes people to fight you. That is not going to be a ruling that the court can make that sort of is looking beyond what the trial court found and to the record as a whole and making a determination.
Your comment makes me remember something else I wanted to ask you. So I apologize for not doing this earlier, but I was looking at DC Code 21-545, which says that unless there's a jury trial, the court shall determine the person's mental condition on the basis of the report of the commission, meaning the Mental Health Commission, or on such further evidence in addition to the report as the court requires. That got me to thinking about what it is that the superior court's determination is to be based on. Is it just the hearing before the court, the trial, or is it the commission report as well? So which is it?
So my understanding is that and I think there's cases speaking to this effect, that is probably sort of embracing the situation where the person who is being committed is not challenging the findings of the commission, which I think is the norm. When those findings are challenged, the commission report is essentially a charging document. I think it's been equated to the grand jury determination. So it doesn't have any sort of actual legal effect. It's directing the court's attention to particular issues that it thinks the court should be considering in its review of the evidence, but it is not evidence of anything. The second point that I wanted to make is there was a lot of questioning about, whether these hypotheses that Dr. Zaidi has made about what will happen to Ms. Dutton and whether or not they're consistent with her experience in the community. And just to be very clear, Ms. Dutton, the record is that Ms. Dutton was very successful for 15 months in the community. She had 2 of these outbursts in the community. She is supposedly having them quasi-daily at St. Elizabeth's because she is so furious about the liberty deprivation and being reminded of a mental illness that she does not believe she has. But in the community, she does keep to herself. She is not having outbursts all of the time. And in fact, at the shelter, she was so successful that they moved her from the 2nd floor to the elderly unit, which is a privilege that you only receive if you are compliant with rules and have no behavioral issues. So that is the nature of Ms. Dutton in the community. She is obeying the rules and she is taking care of herself. And as far as the sort of 3rd FD12 goes, that is one instance of disorganization and sort of a record of her being just fine with taking care of herself in the community. And her response, I think it's very important to focus on the fact that her response when she was having headaches and she was having pain was to ask for help getting medical care. It wasn't to just sort of sit there and allow herself to descend into, a critical medical situation. And that is a distinction from a lot of these cases that we look at that are about medical needs. A lot of the times, look at Artis, which is cited by the government. That is about a person not taking their diabetes medication. And the findings there were that Artis is in the community, chronically incontinent, unable to bathe herself, and will not take her insulin, which is could very quickly create an urgent medical issue. And it's very different from anything that we have in the record with respect to Ms. Dutton. The other thing I would just like to say is I don't know where the representation comes that Ms. Dutton has been ruled out, that a dementia has been ruled out. That is absolutely not the case, as far as I know. And I think I have a pretty good understanding of that situation. So that is sort of an ongoing issue in Ms. Dutton's care, the question of dementia. And I just want to emphasize in this court's consideration of this, if this basis for keeping Ms. Dutton at St. Elizabeth's is authorized by this court, there is no way out for her. She is not improving on these medications. She's been on them for 3 years. You have the Commission on Mental Health saying, what is going on? We have not seen any significant improvement on antipsychotics for 3 years. That doesn't make sense. They're asking for a medical review. They're bolding and underlining in their directions that you need to do something about Ms. Dutton's condition. So if we are essentially authorizing what will amount to an indefinite detention, and given Ms. Dutton's age, it could amount to a lifelong detention. And so given the significance of the liberty deprivation here, the sort of questionable nature of the diagnosis and the treatment that she's receiving at St. Elizabeth's, we think that it's important to keep those in mind when authorizing this kind of severe liberty deprivation against Ms. Dutton's will.
There are a couple places in the briefs, I guess, where it's pointed out, or a couple places in the record where it's pointed out that when one of the earlier commitment orders expired, Ms. Dutton remained in the hospital on a voluntary basis. What, if anything, is the significance of that for this appeal?
So I don't think it has significance in this appeal other than to show that Ms. Dutton perhaps is a pretty good rule follower. But I think the reason that she stayed, my understanding is she wanted her day in court. Ms. Dutton is very adamant about, very opposed to what has been done to her, and wants the courts to hear her position on sort of the liberty deprivation she's experienced, which she views as something that she's experiencing based on her speech alone.
I saw that reference to her wanting her day in court, and I didn't understand how her remaining there got her to the day in court. Can you explain that?
So my understanding is that, and I'm perhaps, again, going to be revealing my sort of the fact that this is a new-ish area of law for me. But my understanding is that she wanted to challenge, they had already submitted a commitment order for hers. It hadn't yet gone before the commission and was going to go before the commission. And I think, to be honest, I'm not exactly sure on the reasoning. I know that Ms. Dutton's belief was that she needed to stay at St. Elizabeth's, prove that she was sort of, I'm not sure exactly what she was.
That's fine. I just
I think-
want, I have one stray question and then I promise it's the last one. I noticed on the caption of a couple of the transcripts, it says something like In re Diana Dutton and Philip Candelas. Who is Philip Candelas?
I'm assuming that Philip Candelas is her guardian, perhaps. For maybe.
Oh, maybe the former guardian.
Yeah, former guardian.
Oh, okay. Thank you.
Yes. So if there are no other questions, we ask the court to please vacate the trial court's commitment order. Thank you.
Thank you, Ms. Williams and Mr. Levine, for your briefing and your arguments today. The case will be submitted and court is adjourned.
All right.